Conceptos básicos de valoración de marca. ¿Qué debe saber? Juliana Gonzaléz, Ingenio Avalúos, Colombia. Moderador, Antonio Villa, Berkemeyer, Paraguay.
Good afternoon. I hope you're doing fine. It is a pleasure to greet you from ACP's digital platform. It's a pleasure to be here with you. I would like to greet you all. Stay safe, stay at home, and work a lot. It's a pleasure to be with you this afternoon. We're going to speak about brand valuation. This is a topic that always comes up not only in industrial property congresses, but in all types of congresses and M&A, because these assets are always subject to discussion and to see how much these are valued in the market. So we have the pleasure of introducing Juliana Gonzaléz from Colombia. She is a lawyer, graduated from the University of Santander, and has done postgraduate studies in international business from University of Andes. Sorry? She specialized in administrative law, a master's degree candidate, the commercial rights, and always specialized in contracts and damage at the University of Salamanca. She is a registered valuator in intangible and tangibles, and since 2014 she's a manager at the law firm. She is a valuator. So, Juliana, welcome. You have the floor. Thank you for the introduction. So let us start expressing our thanks to the Executive Committee of ACP, to Mr. Jorge Chavarro and Camilo for the introduction. I'm going to speak about brand valuation, and this will be done from a practical standpoint and also as from lawyers to lawyers. The concept of brand valuation, it has a financial concept, a legal concept, many technical concepts, and that is why I won't go into the mathematical models and formulations, but I want to give this a practical approach and to draw conclusions regarding the response to what a lawyer should know who works on intellectual property regarding brand valuation. So we ask ourselves, what happens when we speak about brand valuation? Maybe the first thing that comes to mind are the rankings, the international rankings, where we associate the concept of brand valuation of great brands. For example, here we see a very well-known journal which tells us about the most valuable brands for 2020 and for the study that carried this out. This is another study showing us these most valuable brands internationally. Now, at national level, we see publications. This is one from Colombia, Portafolio, which show which are the leading brands in the country. And the arrow shows that this study was done by Compass Branding. So this will become meaningful further on. According to Compass Branding, beers 4 brands of beer in Colombia are among the most valuable brands in the country. This is another study of 2020. This study is another one of 2020 from another consultancy, Cantor and WWP, which shows 2 of the brands of Compass branding. So we see that there are differences between one consultancy to another. If you look at the right, we have the top of mind of 2020 with an arrow. I highlight the brand that is top of the mind in the consumers, and this is Colgate. These are studies done in Colombia, and this is done by another company. So we see now that there are several players in the market, and depending on the model, they publish studies. This is the first approach many businesses and lawyers have with the issue of brand valuation. Then there are other studies such as top of mind, show which are the most valuable companies. So these might be related to one another, but not necessarily. One would assume that a brand such as Colgate, which is at the top of mind of this study, should also rank at the top of the other studies, but this was not the case. So all the methods measure different things. The purpose of all these rankings measure different things. In this slide, we see one of the most common errors that are made. This portal makes this mistake, and also many people too, which confuse the value of the company with the value of the brand. It states the Colombian businesses among the most valuable Latin American businesses in 2020. And Brand Finance tells about the 100 brands which are the most valuable. So when we speak about brand valuation, we have to refer to one thing, but among lawyers, we see that some valuations had to do with transactions or negotiations between companies for licensing purposes, but this is one of the important points. So this has consequences, and this is that the brand valuation is associated with extraordinary brands, which are the minority of those registered in a country by SMEs. I think that this is a situation that is probably similar to situations you have in most countries. In other words, most of the brands are not included in this ranking, which we have just shared with you, so that you have some statistics. During the weekend, I checked how many brands were registered in Colombia, and we have 40,000 that were filed for licenses. So this exercise of brand valuation is not necessarily related to the rankings I have shown you. Another thing that is not shown in the rankings is the independence and clarity of the information. In some rankings, we had some brands and others were not, whether these were for 2020 or for the same country. And this might explain why the results were different. And the results are not always published in a transparent way. Sometimes these are companies that deal with marketing, and their clients are the owners of some of the brands that are being evaluated. So this in turn leads to possible confusion in the sense of things that might be related with one another but are different. It's not the same to value a brand than when you value a company. So what we see here is just one of the sides. Then there are other reasons, valuations that are done for accounting reasons or for economic reason or to deal with a certain litigation. So first of all, we have to demythify the issue of brand valuation as lawyers. This is a wider concept in terms of brand valuation. This is a process whereby this is from a book of Gabriela Salinas. This is a process whereby an expert, a qualified expert, which has to be certified and registered in the Open Valuators Registry, has to issue an opinion on a certain asset. So they issue an opinion after analyzing data on the value of a brand based on a series of premises and hypotheses for valuation purposes. For example, financial, legal assumptions intrinsic to the asset and in a given moment, because the value might change depending on the moment. And this bearing in mind the objectives for which this opinion was requested. So this will also determine the method. And who will use this information, who hired the information, and the user and the destination. So ACIPE asked us to look at the origin of this history. So brand valuation began back in 1988, and this was from the mergers and business movements that started to occur in those years. I apologize for the photograph, but this is a New York Times publication of that years where Grant met, which we now associate with newspapers, purchased Pillsbury, and 90% of the price was attributed to the brands. So after that, we started to see the need of valuating intangibles in order to determine goodwill, which we see is a concept related to brand. So very rapidly, these are English models, and in Latin America the history is much shorter. I will tell you about the history in Colombia. In the 90s, there were 10 valuation methods. Today we have many, many more. So this is something that grew over time. And as I said, in Colombia, the history began in 2013. In the past, valuators could value anything from movable to an intangible asset. So based on that, the valuation service was professionalized. This is a law 1673, enacted in June 2013. Several categories were established. This includes the intangible valuators. This regulation had a transition regime which reached up to 2018. So this is the intangible valuation which has been applied since that time. Valuators have registered, and this is information that is published, and the total amount of the registered valuators are 6,300. From these, 214 are valuators specialized in intangibles. So you will determine which are the assets that are most evaluated in Colombia, for which there are many more professionals.
So that is basically the story. I'm not advertising. There's only one program at the Universidad de Externado de Colombia for this specialization to value assets, and is especially focused to intellectual property. Before this, there was nothing that would allow us to learn about this except practice. And in the past, this was carried out by investment banks. But I insist, up until 2018, it was in 2018 that Colombia started talking about having a specialization in the topic. So the valuation of intangibles has a technical component, a financial component that I will try to explain now. So let's see what a standard, approach, method, and model means. There are valuation standards, there are valuation approaches, methods, and models. So let us explain the pyramid. You know, this is a familiar image. The base is made up of standards, the criteria and procedures that we follow. This is provided by authorities in the field, like standards for intellectual property that the Universidad Externado and other professionals created. This is Colombian. And the legislation, when the valuation has an accounting or financial purpose. On top, we have the approaches. This is the overall way in which we do economic valuation of any type of asset. This is what we put emphasis on. We see that valuation can put their emphasis on the cost, the asset, or other things. Method. This means the financial variables that have been recommended to evaluate certain assets like tangibles, intangibles, and models. Over 50 models that have been coming up to assess suppliers, for example, a very well-known company in finance and another one well-known in marketing or branding, and they talk about their own models. So when we talk about approaches in valuation, we have three approaches. One is based on the cost of the asset, the other is based on the market, and the other on the income. Now, the field of methods, we have more methods that can be associated to approach. The method of historical cost refers to the cost of creating the asset, how much I paid for creating a brand, the cost of replacement, the cost of capitalization of expenses, like the accumulation in advertising. In terms of intangibles, there are different methods that we can use for some intangibles or are not useful for other intangibles. To value a brand from a cost approach or a method may not show the value of the brand or its potential in future. That is why under remarks we say that this type of method do not capture the value of intangibles in future, and they should not be used to value the brands. That is not the case true in the case of other intangibles. But in patent, we need a cost approach or a method like replacement or capitalization of expenses. The other approach is market. You compare with similar transactions. And this is very complex because we do not have an active market in brands, or brand with similar characteristics may have a value similar to the one we are analyzing. So what method am I going to use to verify this? Some authors include royalties and licensing, but we see obstacles. How far can I compare licensing of certain brands with the one I am valuing? Then we have the income approach, which is much used in brand valuation. This takes into account income generated by the brand. So there are direct methods like the premium on price, and you compare the product with a recognized brand and a generic equivalent, and that premium or difference is paid by the consumer. And this is what he pays because of the brand difference. And this is a value that can be allocated to that asset, to the value of the brand. And there are indirect methods that are a little bit more simple. It's to get to the residual value. And this is basically to take the value of the whole company, deduct the tangibles, and get to the conclusion that the value exceeding that is allocated to intangibles. And this also, as you can realize, just to mention a few methods, all methods have what I would call, well, what leads to discussion, what is controversial. Some will lead to more discussion than others, and these are the flaws that we need to look into as lawyers when we deal with these things during a litigation. If they accompany the sale of a company and they include the brand value with a method that is questionable, we should try to apply another method that is more convenient or less controversial. Now, under remarks, you will see that even methods that are income-oriented have some exceptions. In savings and royalties, there are some rules that say that you apply the 25% rule, and another one says you apply 5% on sales. So where did the rules come from? Some scholars said 25, others 5%. And this no method will be useful if we apply this. And we can value the same brand with two different methods. The results will be different because we will be working in different categories. Now, some methods are more recommended than others. The minimum price of a brand, or the floor value, or a higher value, or the ceiling. Now, valuation models, in turn, are created by academics, by suppliers, and these are hybrid. You have an income approach and a costs approach, and there are about 40 or 50 such models. Some you may probably know, like the Interbrand. It's been in the market for a long time. There is a Japanese model, Hirose. I don't know if it is well pronounced, Hirose. It's a Japanese method. They found a very important difference. If in Japan, the minister did not impose this, but suggested to the brand valuation committee to use this Hirose model, to have just one method. Then we have the Damodaran model. He is a professor of finance in New York, and this is a benchmark. It's very updated, and we can consult some rates of discount. It's well known. This is just to show you that there are many, many models that apply in different countries. And the important thing is that this is technical and sustainable. Look at this table. It's on one of the methods I've shown you. This is Interbrand. It takes 4 health pillars of the brand into account. It measures differentiation, relevance, esteem, and recognition. Then it determines whether the brand has a power grid, if it's a leader, if it's declining, if it's eroded, and it measures the power grid of the brand. The Interbrand model has a table, its own table, and it scores different valuation criteria. So for leadership, this is a branding firm, so leadership, stability, and marketing of the brand, it has a high score. And if you look at protection, which has to do with legal issues for the protection of the brand, it's only 10 points. You may disagree with this, as I do. I would say that this is not correct, that protection is much more important. The brand has to be legally protected. I would score it higher. But this belongs to a large company. And here we have an example from Colombia, Compass Branding, with its own table or scorecard. And it's divided with brands with a potential, threatened brands, leader brands, and consolidated brands. So there is no single regulation. We may have new models in future. But what is important is to have models based on methods that are based on recognized standards. Let's look at a practical brand valuation case. Do I still have time? I don't see the watch, but so let's look at this practical case in brand valuation. This is how we proceed with brand valuation. I'm a lawyer, so I give relevance to the legal status. If there is no registry, we need to have a valuation with some exceptions. So first of all, we need to check the legal status of what we are valuing. In Colombia, it is compulsory to be registered in order to enjoy the rights. We have valued applications that are ongoing, that are related to certain situations, and we use the concept of feasibility. If the brand already passed the formal examination and the publication is going well, and this brand can be granted, there is no opposition, and so on. This is all very important for us. So we have to value affectations and duties and taxes. In Colombia, there is no embargo on brands yet, but it may come in future. We need to check all these fiscal issues. We have to study the history of the asset we are valuing. And of course, there should be a correlation between the income, whether we use the income approach vis-a-vis the granted rights. Some brands have been granted rights, and they work with intangible assets. So we need to look at that correlation, because maybe we are doing brand valuation with a brand that is not registered or has no rights according to this relation. We evaluate intrinsic characteristics of the brand, and this does not appear in previous models, though we consider it's very important because the value in the market is quite different. Here we see two axes. The first one shows the level of knowledge about that brand, primary, significant, or has the status of a renowned brand. On the other axis, we see whether it's generic, descriptive, it evokes something, it's arbitrary, or it is fantasy.
So the idea is to determine whether a brand has a greater distinctness depending on where it was originated, in a geographical area, or whether this was conditioned by the national office. Because a generic brand should accept coexistence with other brands that are equal or similar. So in this table, this is a table we use in order to determine whether the brand becomes worth noting, and this will have to have an impact on the method and on the financial analysis exercise we do for the purpose of valuation. And then we have the financial analysis and method selection. So this is something that is done with different stakeholders to determine what is creating value for that brand. There we look at the numbers and the financial statements in order to determine which is the most appropriate method and responding to the finality, to the purpose of this. So this will depend on several factors. Now, there are different methods that give more or less relevance to certain factors. As I said, this is a real valuation. I crossed out the brand for confidentiality reasons. And here's using the valuing method called saving in royalties. The value of the brand X as at December 2019 would amount to 6,222, means the same brand, using a different method, which is excess cash flow. It gives this a different values, 12.4 million. And this is another valuation. And this is what we present to the client. The brand should not be more valuable than the entire company. This is the free cash flow and the total value of the company. So in other words, in this case, those who hired us wanted to sell the company at a reasonable price using the excess cash flow. And this was the value because the analysis allowed us to conclude that the majority of the income, the strong part of the business of the company, was the result of the exploitation of this brand. So you can note a significant difference in the value of a brand applying one method or another. What should lawyers know as regards brand valuation? But before going over to that, I would like to speak about the cutoff moment when this valuation is carried out. This year, as a result of the pandemic, many restaurants and many companies related to food have been seeking to value their brands. So they said, well, let us use a cutoff date, December 2019, which was pre-COVID. Others said, well, as at April or May or June for the financial statements, because, well, they said this is an exceptional situation. Now, those who are seeking to evaluate their brands in the same niche realized that this is something you cannot determine how long it will made. So the idea is to determine the cutoff date as at December or October 2020 because of the financial statements and also the business model because of the margins that they now have to pay the delivery companies. So we really have to analyze the different variables that might have an influence on the valuation as well as the moment in which that valuation is carried out. We need to have an interdisciplinary team with people from the finances area, the accounting areas, and also the lawyers, because evaluating intangibles and brands has many factors that can have an influence on the result of the value. So now let us have a look at the practical aspects that we have to take into account as lawyers of intellectual property. So I have several questions here. First, what? To determine what is the asset to be valued, and sometimes what seems obvious is not so obvious. So we're going to do a brand valuation. We also have to determine what type of brand generates more value or is more adjusted to the objective of the ruling or the opinion. A trademark can be specific or can be the brand experience as a whole. Some authors refer to different brands like Viagra, which is a brand which might lead us to have a given value, but if we value the evaluation in a more holistic way, we see whether this has a tridimensional value or we associate it to color. So this will lead to different types of values. So we have to see whether we are doing valuation of a brand or an organizational brand, because this often occurs when the name of the company coincides with the name of the product. The business brand can have a strong influence. This depends on the business model, the business values. There are many intangible resources, such as human resources, which although they are intangible, we cannot speak of them as assets because this is something that the company cannot fully control. But this does mark a difference. That is why the question we ask is whether we are doing a brand valuation or the entire business associated to that brand. And this is something that is quite common. So sometimes I'm not sure whether you have to value the entire company or just the brand, or sometimes just wish to value the brand, but whether a brand that made up by several distinct elements. So we really have to determine what we're going to do the evaluation of. Another important question is who is going to carry out this valuation? And I must admit, when I prepared this presentation, I thought which was the legal value of the valuations of the rankings. In Colombia, law 1673 determines who can carry out a valuation. A evaluator has to be a physical person who has the required training to conduct valuation of a given type of assets, and that has been registered in the Open Valuation Register. So we as lawyers have to be aware that those who are entitled to sign a brand valuation are physical persons. So as I said, these are valuators who are registered in the Open Valuators Register. For example, you can have a certification to value real estate, but you cannot value intangibles. In addition to that, there are other requirements. We have to know which is the team that is behind to support. So if we are evaluating an intangible asset, we cannot entrust this to someone who has not specialized in this. So we really wish to have someone doing the evaluation who has been trained for that purpose. So an intangible asset should be approached from a financial and accounting and intellectual property standpoint, as well as by the support team. Maybe it is advisable to carry out market research to really determine how to support the professionals. But if we're going to do evaluation of an IP asset, next question is how. Once again, we define we look at the law. Evaluation is the activity whereby the value of an asset is determined according to methods, techniques, and criteria and tools that are required and timely for the purpose of that opinion or ruling. This ruling on the evaluation is called valuation. So the important thing is that these are necessary and timely, and I would like to add that these are reasonable and sustainable in accordance with international standards and also national standards if these already exist in the country, as well as to the required standards. And if we, and this is a simple equation, if we know what we're going to do the evaluation of, who, then we know how this will be done. So what plus who equals how.
When to value? Of course, in business transactions. And I think we should leave the 80s when it all started. We will continue doing brand valuation for transferences, for M&A. Second, for accounting activities. And I think in general, in Latin America, this is very recent. And here we have NIC 38 on the intangibles and their incorporation. So there will be more and more a need to value intangibles. Then brand litigation. Net worth settlement. It was not usual to see this in a will or a divorce to include intangible assets. You would get divorced and people would not know that they had this. Now it has become an asset, and it's of growing importance in this type of situation. Also to estimate royalties in the case of licenses on or franchises. And another very important opportunity to value the brand is the search for capital. These are assets that you can take to a bank to obtain funds, and this can be used as collateral. I don't know what happens in other countries, but in Colombia it has been quite complex due to the price difference I mentioned. In Denmark, a valuator would say 1 million, 2 million. So what will the financial entity decide in the end? To design these models, this is probably for some very meticulous companies, because intangibles are becoming more and more relevant. And there are other situations, like one of the criteria to show notoriety. That is the accounting value of the brand. So in short, there are opportunities, many opportunities for brand valuation. We need to demystify what happened in the 80s, where only big transactions, great mergers had a need to resort to it. And as lawyers, we have to start looking into this issue. In the past, due to a lack of professionalism, there was more prevention as to the methods and techniques to value tangibles. But we are becoming more and more professional now. So there will be a point when all these things will be more feasible as a collateral also. And I have another question. What is expected of lawyers in terms of brand valuation? The right protection of the asset we are valuating. Unfortunately, we've found brands that are well positioned, that generate good income, but are not rightly protected. They are misclassified. There are portfolios of brands that have a risk because they have not been used for a long time, say in the last 3 years, or the type of register which has been positioned, the graphic element of a brand, and they only have a registration for the nominal brand. And if all this falls in the hands of a professional evaluator, it will be well managed. This will lead to an optimal value of these assets. Second, the initiative to use them as collateral in credit operations, to really structure this type of asset correctly so that the intangible assets allow us for a technical and well-sustained brand valuation, so it can be used as a collateral by financial institutions. I guess that other countries also mentioned this, especially for collateral when you buy real estate. And intangible assets, if we talk about brands, could become this type of asset that could be used as a collateral or warranty. To expand the when, this question of when to do the brand valuation, and this is demystifying the intangible valuation, to abandon or break away from the 80s and do something differently. To know that the economy is moved by the brands of small and medium-sized companies, and then add value to this fact, and then suggest scenarios that may contribute to a market that is better informed and more technical in terms of valuation. In the past, I used to complain about the prejudice caused by different offenses. And as a lawyer, we were not giving them the tools that they needed to determine the loss of value of a certain brand. So if we, as intellectual property attorneys, sustain the value that the brand lost by evaluating the brand in a technical way, following a methodology, even in those processes where we use the pre-established compensation mechanism, we can take this to the court as evidence. Maybe we will gradually contribute to brand valuation becoming an activity that gets closer to intellectual property disputes and lawsuits, and we will start providing this idea to consumers and manufacturers that brands have a value that can be measured and that it is not simply associated to rankings. I think, ladies and gentlemen, that this is what I have to share with you. We thought about half an hour. I don't know, we may answer questions now. Well, thank you. We have 40 minutes. So we have 40 minutes for questions, and we already have a lot of questions for you to answer. Juliana. Alejandra Budelo says, in practice, to value corporate secret, what support do I use to control this? You are mute. You have to unmute yourself. Well, this has not much to do with brand valuation, but we've done it. What is the support that the businessman can present for a correct protection of corporate secrecy? We go back to the importance of analyzing these things. If you ask this to a financial evaluator, he will not know how to answer about the support or legal base to talk about corporate secrecy. It can be evaluated. We have to look at the support to protect business secret, and depending on the industry, depending on, I think the key here is protection. So without protection elements, we cannot evaluate. It's not an intangible such as the brand. It's different. We question this, whether we can value intangibles. And corporate secrecy is one of these things, like list of customers, your goodwill. There are many intangibles that could be discussed, and we need to determine the protection. And that intangible must be generating some income. That intangible, that secret, creates income. The generation of income may have an impact on brand, secret, patent. So how much weight are we going to allocate to such intangibles? Thank you. Following that line, I have a question, and I wrote it while you were talking. When you talked about having all the tangibles for a complete valuation of the company, you said you can use several systems or methods. But one of the methods you mentioned was to have all the tangibles, then discount them, and the rest would be, what would you do with brands? I guess the system works depending on the type of service or the type of good that the company provides. And the brand is related to that product or service. For example, a technology company produces a specific software called a specific name. And maybe all these brands relate to the service and they are sort of generic. This is where my question is headed to. Let me see if I understood your question. It was the method we mentioned is residual value. Look at the value of a company, remove all the tangible, and then see what is the highest value, that residual value, and then allocate it to the intangibles. But this method poses a difficulty. Depending on the company, can I assign to the value, the whole, to the brand, the whole value of so many intangibles? Many intangibles may impact the residual value. Could be copyright. There are many other intangibles that may have an impact on that. So the key is to understand the company, understand what are the whole factors that generate value. The brand could be not so important. Some companies have registered a brand, but that is not the main intangible, because the value is in the software, for example. It may be the case. So the method has this but, and it can only be solved if you do the right analysis of the company. Now, this could be the case when you sell the company or you sell part of the shares. Sometimes the big mistake in this type of method is that you do not value the tangible well. You talk about traditional methods to value companies, but companies can be valued financially in a global manner. Just look at the financial statements with some variables, but they can be valued on the basis of all the fixed assets that are part of it. A software company is one story, and a company that rents construction machinery, that's a different thing. If you look at the global or financial valuation, we have to look at amortizations and other accounting issues in the hands of accountants. But if they are if the amortizations are well controlled, otherwise you need a much thorough work to value the company by looking at each asset in particular and determine which are the most important fixed assets as reflected from the financial statements, and then you apply the residual value methods. There are many variables that have an impact on this. When you talk about goodwill, for example, it's residual. This is the way it was done in the 80s. But the highest value can be residual value. So is it related to goodwill? Is it related to other issues? Excellent, excellent. Thank you. You answered my question. I have another question from Camila Flores. In practice, have you seen methods where the final value of the transaction depends more on the negotiating capacity than on the technical support? Absolutely, yes. Yes. one thing is the value, the other thing is the price you end up paying for this. That's why I placed emphasis on the objective of evaluation. Oftentimes, who is willing to buy? And this involves negotiation tools. If I have a privileged position in the market and I'm saying my company and my brand, that position to my competitor, that needs to be capitalized. And we should try to look for methods to value the intangibles. And the top is the price. We've seen transactions that are struck with in different ways by simple negotiation.
Great, thank you. Now, going back to that point on the negotiations, I remember that you mentioned that one of the purposes of brand valuation is during lawsuits. For example, a company is sold, and if the shareholders have an issue, then a valuator has to do the brand valuation. Each specialist chooses a different method. For example, as you showed in your example, that shows differences in millions of the currency, the relevant currency. So how do you consider that one can reach a good conclusion because there are so many different methods? How do you justify this use of one or other method? Well, legally, at least here in Colombia, you have your evidence and your counterpart can have a different ruling. And then you have the option, and this is another key point, of the evaluators that go to the lawsuit, because the party, the judge, the ruling of the counterpart can, this depends on the judge has to know that there are different methods that are equally valid, and your ruling, if you cannot defend it, can be destroyed by the lawyer of the counterpart. Now, normally what I would recommend, and I insist this largely depends on the negotiation capacity of the buyer and the seller, but very often a third valuator, both in the judicial and extrajudicial stage, can be called in. The value has to respond to a code of ethics and to obligations, but nevertheless, this is your valuator or the evaluator hired by one of the parties. So the method will be applied depending on the scenario. This largely depends on the subtlety of the evaluator. Now, if there's a very big risk in one or the other method, it would be good to state this clearly. So the idea is not to lead to a situation of lack of proportionality. Of course, each evaluator will defend the interest of the entity that hires that evaluator. But the evaluators really have to have a technical record, and they have to respond to a code of ethics. In Colombia, it is forbidden to agree the fees to be paid subject to the outcome of the ruling or the decision made by the judge. Now, going back to the extrajudicial aspect, maybe a third party can be called in to make a objective and critical opinion on the two different valuations, and so trying to strike a balance or come to an agreement between the two sides. I have another question. In LATAM, there is no culture on intangible assets. What is more, companies very often don't include this in their account, in their balances and in the statements. How can you would you like to respond to that?
Sí, ¿me escuchabas, Juliana?
Can you hear me? You had muted your microphone.
Está mudo, un segundito.
Listo.
Ahora sí.
¿Sí? Ahora sí.
Sí, sí.
Claro. Y eso...
Well, precisely that is one of the problems. I would describe this as a best opportunity for improvement, that of the intangibles. This is a joint effort to be done by accountants and lawyers and to demystify this. Now, in the context of valuation, many holders ask for brand valuation and consider that these services should be done at very low cost. They have a reference of valuating a real estate, and they think that valuating an intangible asset is similar. It shouldn't be extremely costly, but it's not excessively cheap, because this implies a specialization. But some companies deal with this quite adequately with the support of the lawyers of that firm that are knowledgeable on these topics. But the law was enacted only recently in 2018, but some lawyers don't even know that there are IP valuators. So as lawyers, not only on IP rights, have to try and raise the bar, and we really have to look at these issues when evaluating a company. We have to view not only the company as a whole, but really have to distinguish each of the assets that make up that company. So this is a culture that will be able to expand among the advisors too. This is the point of recognizing the importance of intellectual property and the awareness of these intangible assets. Thank you very much. I have a question too that is more like a recommendation for those professionals who are listening to us. This has to do with how to support clients so that they have their brand portfolio. This is at the moment of selling a brand. How can this be explained to clients that have to have an updated portfolio of the values? You mentioned the top of mind. These are awards that are handed out every year. Top of mind 2019 or top of mind 2020. So how can you give an additional drive to the brand? So the idea is to offer this to clients, and on with what frequency? I think that we should be aware of the needs of the customer. If they are small or medium businesses, many companies are really focusing on that, but they don't have tangible guarantees or fixed assets to apply for a loan. So these businesses have specific needs, and based on the evaluation of such intangible assets, which is a major part of their assets, then based on that, we could offer them to do an asset valuation. There are other larger businesses that, if they wish to enter such rankings, could do so. But if we speak of the top of mind, we're measuring different types of things. So we should, in that case, try to find the brand positioning. This could be more like a branding business that is focusing on that. But how frequently to do these valuations? Well, if you have clients that have indicators, for example, that are measured every year, and this can be used to adjust their brands and to see how much value was generated by a given brand, and eventually to allocate further resources to publicize a given brand more than a different one. So I insist there are many opportunities out there. So it would be worthwhile to organize a talk on these topics. For example, there are cases where it is really important to do a technical valuation. For example, when there is a divorce, or in the case of inheritance, there are situations when it is important to have duly valuated assets. And so I think that the culture is changing and will also be requiring and becoming more and more demanding on these topics. The important thing is that lawyers are aware of this. And we have to see how we can incorporate these services.
Sí, gracias, gracias. Tenemos unas preguntitas más que fueron llegando. Bueno, María José Sánchez Rey.
María José Sánchez Rey. Stepping apart from brand valuation, you also referred to patents. There are intangible assets, but what if the object to be evaluated is to negotiate royalties and the registration is in the process of being decided, and the percentage of the royalty cannot await granting this patent? What would you do in that case? Well, that is something that happens quite frequently because of the time that it required to register a patent. And this is with unregistered brands or trademarks. To register a patent, you have different methods. This is done very often by engineers. And we have even suggested what could be the most interesting markets for such intangibles, and particularly for patents. It has often happened to us, and this is a risk run by many inventors, that when the patent is valued, then the technique might have changed, or it's then obsolete, and this has an impact on the value. That is why valuation is like a snapshot under given conditions at a given time and moment, and taking into account the specificities of that moment. So when an inventor goes with his patent to a business round, then definitely the valuation can be done, should be done before having the register of this patent. But those who will be purchasing this patent, if there's someone who's very interested in purchasing the rights resulting from a patent, whichever the status, whether registered or not, should be aware of this situation. In the case of brands, the situation is different. The more time goes by, it can be more valuable. But this is not the case with patents. In the case of patents, it is quite different. In that case, it would do the evaluation provided the features and variations are taken into account based on which that ruling was made for that valuation.
Excellent. Thank you. My final question from Jose Roberto Romero. Some accountants think that intangible assets are annually depreciated as other assets. I think that's a mistake. What is your opinion? Well, I will try to answer. I also think it's a mistake because accountants do not know how to manage the valuation of intangibles. The accountants are in the process of learning about it. These are the intangible assets. They were not relevant. Nobody talked about them in the financial statements. They don't even study that. But there has been a gradual evolution. And they start wondering how to deal with this. In NIC 38, the assets need to be defined whether the shelf life of that asset is finite or indeterminate. I think that brands can be renovated forever. And from that point on, we study depreciation. So we should look at that. As this is an asset with a shelf life that has not been clearly defined, amortization or depreciation should be different and will depend on the policy relevant. Thank you. Thank you, Juliana. I wonder if you want to close this meeting. Do you have any other message for the public? Maria Camila says that I need to answer a question. No, I didn't get that last question. Let me check. No, I haven't got that question yet. I will share it now then. I'm sending you what Maria Camila sent me. Sorry for this delay. I will read it now. How to value an international brand that has an important presence in all countries? A very good question. Brand valuation has a scope like the protection. I'm an evaluator for the Americas, and my valuations are valid in Colombia. Now, depending on the legislation of each country, you may transport this valuation from one country to another. This has to do with the legal validity of the examiner or the evaluator. But one of the criteria or inputs that could give more value to the brand is the international presence, and does not have to be notorious. The success of the valuation lies in the fact that this qualitative analysis of the brand, its international protection, its international position, could be translated or conveyed financially. This also depends a lot on why we are doing brand valuation. Is it because we're going to sell the brand or not? Or whether its position is important in other countries. In that case, we should conduct a more profound analysis of the marketing and the branding to show its international performance or standing. I think the success depends on the right method, and then see whether this result is valid on an international level. That's another issue. It depends on the professional. Thank you. Excellent. Juliana, I think that we can now close this event. You've been talking all the time. You have shared a lot of information, and we now can understand this new world much better. This world of brand valuation. Talking about other issues as lawyers is not easy for us. Do you have some final remarks to share? No, Antonio, I just want to thank you. And I know this subject is a little tough. We try to understand valuation methods. This is not easy. That's why it is important for us to take our time and understand. For us lawyers, it is difficult to understand the world of finance. I would have loved to have an expert in finance or accounting, but as this presentation was for lawyers, it was valid to spend an hour and a half talking about my ideas. So thank you for this invitation. Thank you, Juliana, for your time. Thank you. And next time, we'll invite experts from the financial field so that we may learn new things. Thank you for this opportunity. Let me thank Elizabeth, Sylvia, and the board. And I hope you continue enjoying this platform, which is working so smoothly. We thank the possibility for having this virtual encounter to keep on learning. Thank you. Good afternoon. Bye-bye.